Now, relative is also underlined, so this is also changed. Relative means a person related by blood or adoption, or a Hanai relative, as defined in this chapter, who is willing and able to safely provide support of the child and families determined by the court department. So, I think the key thing to notice here is that Hanai relative is included in the definition of relative.
No question.
Yes.
Where do a foster parent fit?
See now, a foster parent could fit in under this Hanai relative. You know, so if you're a foster parent, it plays a central role.
So you take a kid away like 3 months old, and you have problems with visitation. So the foster parent has this kid all this time. So now the foster parent has the kid for so long they don't bond with that kid. So now the foster parent can adopt.
Yeah, I see what you're saying. Yeah, now if you're talking about foster parent, now that's someone where CPS has already gotten involved in. You know, and CPS already has placed the child with these foster parents, and these are like not relatives. Yeah.
Can't listen.
Yeah, well that's a tough one. Now, that's where that happens in they fall out. They're totally separate from this. This is not relative and relative. They're foster parents, so they have a legal recognition by CPS as being the foster parent. But that issue did come up, and that kind of comes in later when we're talking about this, the notice. Yeah, so you're saying that if there's a case where they're talking about placing the child, you know, permanently, and the foster parent is battling with the relative, just like that.
Well, CPS is battling with the parents, and you feel that they want the kid to have no bond with that mom or that dad, so they put it into a foster home.
Yeah, that's really unfortunate when that happens. And this bill is seeking to prevent that from happening in the first place. Because then once that happens, there are some protections that we tried to put in. I think it might be a separate bill that says that by the time you get to the court process, then you have to give notice to not only the foster parents but also the relatives who want to be noticed. But then at that point, you're almost like on, you know, an even ground because you're the blood relative, but this foster parent has bonded with the child over how long.
The thing is, CPS kept the family away from the child.
Yeah.
So they never get the bond.
See, what year was that?
The previous week.
Okay. Yeah, see, hopefully that was, hopefully before 2008, because this bill took effect July 1, 2008, and it's trying to prevent that from happening. Because if you're in that situation, then that is tough, because then they can, the child is bonded with these foster families who could be not related, but they've been there for a year, say, right? And so now we're getting to the point where the parents, CPS has determined that parental rights need to be terminated because they didn't comply with the service plan. Then they're going to court, and so now you have standing here uncle or grandfather, say your situation, who has not had custody of the child because CPS didn't give it to him, battling with the foster parent who's going to ultimately get custody of his kid. Now, these bills, we can't. The legislative branch is separate from the judicial branch, so we can't tell a judge what to do. We can, if you read this bill, you'll find a lot of places where we're recommending, these are the kind of things you judge should consider. But we always have to leave it where the judge makes the ultimate decision. So that would just come down to the final, the judge deciding and showing that it's in the best interest of the child to be with his blood relatives, his grandfather, whatever is the case. And hopefully that would show, and you could use this bill to argue that, to say, hey judge, this might have happened before 2008 when this bill came into place. And it's unfortunate because CPS never gave me a chance. I called them, I contacted them, wrote them letters. They never gave me a chance to even apply to be a foster parent, Your Honor. This isn't fair at all. Prior to the child being with these foster parents, I was involved. The child bonded with me. She knows me as the grandfather. Those are the kind of arguments you could make to the court. And this bill could help to show that, that there was a problem with that, and that, the legislature acted to correct it. And that unfortunately you might not have benefited from this bill because maybe it happened before July 2008. So, but yeah, I hear what you're saying, and that's what this bill is trying to prevent.
This still happened as of today.
Yeah, but that's why it's important for you to know your rights, because if that happens, then you can press an appeal. If you try to be a foster parent and CPS never gave you a chance, then we should request an appeal, say, hey, I was supposed to get 15 days, I was supposed to get an application, I was supposed to get a response to my application, I was supposed to be told I had a right to an appeal. None of that happened, CPS, I need an appeal.
The CPS will check all family members, exhaust all family members before you can
Yes.
decide.
If you look at page 6, what he's talking about is exactly what this bill also provides, one of the things you folks argued for. Page 6, section 5, item C. I'll just read C. Upon assuming temporary foster custody of the child under this chapter, the department or CPS shall place the child in emergency foster care unless the child is admitted to a hospital or similar institution while it conducts an appropriate investigation. And that used to be the end of it. What the bill added was, semicolon, after that, provided that placement preference for emergency foster care shall be given to the appropriate relative identified by the department. The department and authorized agencies shall make reasonable efforts to identify all relatives within 6 months of assuming foster custody of the child.
What's the difference
So-
between shall and will?
Yeah.
Language.
Yeah, they're both kind of equal. Shall is like that they must instead of may. Usually may, yeah, may is often used instead, which means departments say, I'm going to ignore this law, I don't care. Shall, they can't ignore this. So very important. So what you could do, if your case happened after July 1, 2008, and you can go to court and say, Your Honor, this my grandson or granddaughter was placed with this foster family. Under the law, DHS within 6 months of getting my grandchild was supposed to make reasonable attempts to identify relatives such as me. I called them, I made myself known, they know who I am. My daughter told them about me, and they didn't follow the law, and you'd have to look into the record. Once you've requested an administrative hearing, by the way, you're supposed to have a right to look at the record, at their file, CPS's file. And they're also supposed to give you, let you make copies of the file for free.
What was that again? Can you repeat that?
Once you request a fair hearing administrative appeal, now this is with DHS, CPS I would assume, they might have different rules anyway, with DHS in general, when you request a hearing, you have a right to look at their file. So, because they have a file, on IDIP, they have, it's all the paperwork. You have a right to look at that file, and you have a right to make copies for free of the file. So that's the law when you're dealing with DHS for welfare benefits. CPS, does anybody know, is it the same? Is it the same?
Well, they don't, if it is, they don't.
But when you requested the hearing, those of you that requested the hearing, did they let you look at your file? They did? I have to check. I wonder if there's rules that protect the CPS files different from the DHS files, like the food stamp.
There's privacy because the minor child is there, but if they block out the child's name, you should be able to see it.
The fact that you have a right to a due process right to a hearing, how can they not let you see why what their records are to show why they denied you?
They want you to know what they wrote.
Yeah.
Yeah, that's it.
Yeah. Well, definitely. You have a right to a due process right to a hearing anytime they take adverse action against you. So, I would argue if I was your lawyer, that I'd say, hey, man, right here in the law it says these people have a right to a hearing, to administrative appeal. How can they actually exercise that right if they can't see the evidence that was used against them?
All the time you see them, you go to court.
Yeah. Well. At the hearing, definitely the DHS, CPS has to present their evidence to show why they thought you broke the law. So you have a right to see that evidence. Without a doubt. You're the person affected. So anyway, what's important is knowing about this section, because what you would want to look for if you were, say, the person where CPS is going to take away your grandchild, they're going to put them with this foster family going to the mainland, not even related to you. You would want to look in the record and see, hey, did CPS follow the law? Within 6 months of getting my grandkid, did they try to identify all the relatives? Did they try to find me? Because that's what they're required to under the law. And if they can't prove that they did, then you can say you can argue that they violated Chapter 5.